learned friends of terms like a change in stance or a concession are not appropriate, and we submit that the affidavits of the Public Protector are quite clear that her position has been consistent in respect of the binding effect of her remedial action as against the persons against whom they were taken, namely the SABC and the Minister. And her affidavits deal with non-compliance by the SABC and the Minister in respect of the remedial action taken. The disciplinary committee is a consequence of the remedial action. So the focus of her affidavit was not to deal with the effect of the findings in those proceedings. Her criticism of those proceedings are against the SABC for not complying with the requirement of those disciplinary proceedings being appropriate. So the context is different. The affidavits of the Public Protector address the primary binding nature of her remedial action against the organs of state. They do not address or do not suggest that the findings determine the consequence of the disciplinary committee. That is a refinement, and it's an issue of law, and our submission is that the submissions we've made on the fact that they may not be disregarded would meet constitutional scrutiny and would not be inconsistent with the position taken by the Public Protector, because she had not taken that disciplinary, the remedial action against the individuals to whom the issue is being posed. The question being posed as to what is the effect of the findings and remedial action in the disciplinary process. First submission, therefore, is that there is no change in stance or a concession. It is a refinement related to a party against who is involved in compliance with the remedial action taken. The second issue that I just wish to refer to arises from comments which fell from the bench, and it relates to the question whether the affidavit of the Public Protector, insofar as it refers to impermissible parallel investigative processes, can be a reference to a disciplinary proceeding. Our submission is the context in which that is referred to is aimed at the SABC, and it relates to two occasions on which such impermissible processes were followed. The first was the Mchunu report, and the second was the implementation report, which indicates that advice was taken, and the implementation report is really an explanation as to why there won't be compliance. So that was a second instance of an impermissible parallel investigative process. The disciplinary inquiry is on a different footing. It is a process which flows from her remedial action and can therefore not be described as a parallel process. It is one consequent upon the remedial action being taken. And secondly, the nature of those proceedings are disciplinary based on charges, so it wouldn't be in the nature of an investigative process such as the Mchunu report had been. And that is therefore a distinction which places in context the opinion of the Public Protector that that process would be impermissible, but it would not be in our submission a reference to the disciplinary proceedings. The third point we just wish to make, my lords, is that as far as the findings and remedial action are concerned, they will stand in the disciplinary proceedings regardless of the outcome of the disciplinary process. Our submission is that the disciplinary process is not an opportunity to displace her findings. What we are submitting is that the remedial action will stand in those proceedings and have to be taken into account in coming to a conclusion, but it will not displace the finding.
Her factual findings are not remedial action, but once the remedial action is taken, which is a disciplinary inquiry, I'm not sure I quite now follow your last point.
Yes. All that we are suggesting, my lord, is that the remedial, the findings by the Public Protector, let's bring it home, as far as Mr. Motsoeneng was concerned, findings that he had misled his employer as to his qualifications, and that he had admitted as much to her during interviews, etc. Those are matters which the disciplinary committee must take into account in assessing the evidence before it. But if it comes to a different conclusion, it doesn't mean that the public protector's finding is now displaced.
Well, what is the significance of the fact that her findings stand?
It will mean that that finding will stand as the finding in the Ginwala Commission stood. As far as Mr. Similani is concerned, it will stand forever and a day in assessing the evidence before the disciplinary committee.
So do I understand you properly that whatever the disciplinary committee may come to in terms of arriving at a conclusion,
yes,
the public protector's findings stand?
It will remain the same finding. That won't change.
Well, obviously it will remain the same findings because there is her report. It can't be revisited. But what is the legal effect of that? Because assuming that the disciplinary inquiry properly conducted has the effect that none of the public protector's findings are supported by the chair of the disciplinary inquiry.
Yes.
And as a result, Mr. Motsoeneng is exonerated.
Yes.
Surely it can't then be said that if he then applies for the position of Chief Operating Officer, the findings that should prevail when the Minister and Board consider that are the public protector's findings rather than those of the disciplinary inquiry. That would be a violation, surely, of his rights.
My Lord, that was again one step further from the disciplinary committee proceedings. What we submit that is the impact of them standing is that within this disciplinary, and we're going no further than that, they cannot be ignored, and the finding at the end needs to take into account the fact that there were such findings by the public protector.
Yes, but if the disciplinary chair doing all of that comes to the conclusion that the findings are not made out,
yes,
and Mr. Motsoeneng is therefore cleared of the charges,
yes,
what then? Insofar as what further significance do those findings have on Mr. Motsoeneng's future in the SABC or elsewhere?
My Lord, that we submit as a bridge too far at this stage. We submit that as far as the disciplinary proceedings are concerned, if the evidence before the disciplinary committee is sufficient to, notwithstanding the findings, come to a conclusion that he is not guilty, and there's a rational process in coming to that finding, then that finding of the disciplinary committee would withstand judicial scrutiny. And that is the only impact that we would say it would have as far as the disciplinary proceedings are concerned. What the impact of those findings are in different scenarios are issues that we have not yet considered, and they might depend on the facts of that at that time. But what we are saying is that a chairman of a disciplinary committee does not have the power to displace the findings as such. That might be a matter of terminology, but what we are merely suggesting is that those findings will have to be taken into account. And in this particular disciplinary inquiry, they were not.
Realistically speaking, how does this inquiry work? Let us suppose that persons that we accept are independent are appointed as initiator and chairperson of the inquiry, and the initiator investigates, attempts to assemble evidence, and comes to the view that, let us say, the public protector's findings can be distilled into 6 charges. He comes to the view, I actually don't have evidence to present on 3 of them. That may be either because he disagrees with the public protector's analysis of the facts, or because witnesses and documents that were available to the public protector are not available to him or her. Is it sufficient that the disciplinary process is conducted in a bona fide way? Clearly there must be mechanisms in place to ensure that internal witnesses are not interfered with,
yes,
and are available. But does the internal prosecutor, as would be the case, I presume, in a disciplinary inquiry, have the freedom to determine that certain charges will not be able to be successfully prosecuted?
My Lord, that again is a question which has not arisen in this particular case, and I'm now making submissions on my feet. My submission is that the rationality of putting the charges or formulating the charges is not the real issue. The issue that the public protector directs is that those disciplinary proceedings must be appropriate. And if there are findings preceding it which inform that finding, then the findings need to be placed before the disciplinary committee.
So all those involved in the process must, among other things, consider the public protector's report in full, and we've only seen an executive summary and the remedial action, but there will presumably be reference to a lot of evidence. As a matter of interest, are the interviews that the public protector conducted in that case, are transcriptions of them available? Will they be available, for example, to an in-house prosecutor?
As far as in other matters, as far as I'm aware, there are files in which they are transcribed. They are usually quite lengthy and would not necessarily form part of the report once issued. But it doesn't mean that they would not be available in due course. But returning to the question that has been posed to me, the decision of the prosecutor as such we submit is not the only issue. The question is whether the disciplinary proceedings are appropriate or not. And we submit that the judge, in the process of determining what evidence goes before the chairperson, I'm saying judge in the sense of the prosecutor deciding on which facts to present, because those disciplinary proceedings flow from the public protector's report, our submission is that he would have to place the relevant findings before the tribunal. To that extent, his discretion is influenced by the nature of the remedial action. If he were to say, for example, that I'm putting none of the findings of the public protector before the disciplinary committee on a matter related to dishonesty on the in 1995 at the stage of employment of Mr. Motsoeneng, those disciplinary proceedings would not pass muster because they would not be appropriate. They do not flow from the findings and the remedial action taken.
So probably in the circumstances of this case, the prosecutor would have to present the best evidence that was available on the charges that the public protector has identified and leave it to the chairperson to assess.
That is so.
Ultimately, what is to be made of it.
That is our submission. As the court pleases.
Mr. Labuschagne, I believe that you've got business elsewhere in the country and you would like to be excused. Is that so?
As the court pleases, I beg indulgence to be excused as the court pleases.
You are excused.
Thank you, Mark.
Sorry, Mr.
I wonder, may I ask for some leave to react to what I regard as a new submission.
Well, then Mr. Labuschagne is not excused. He must come back.
What I wanted to say is this. In the light of what my learned friend has said, there seems then to be no weight to be attributed at all to the negative findings against Mr. Motsoeneng personally, because he says the object of the report was really directed against the SABC and against the minister, not against Mr. Motsoeneng. So what weight must then be attached at all to those findings?
Well,
that's the question which I raise.
In the case of the SABC, the full weight, until they are set aside. We are concerned here with things that the SABC has done.
Yes.
Mr. Motsoeneng, in a sense, one might say, the DA might not agree, is not to blame for his own appointment.
Yes, but it completely undoes the immutability of the so-called findings. That what the submission now is, they are just matters which have to be investigated. They're not anything more than that. They're not findings at all. It's just a suggestion to the SABC, you've now got to investigate Mr. Motsoeneng.
Well, essentially, it's in terms of the public protector's report as a result of their investigation. I mean, your client appointed Mr. Motsoeneng.
Yes.
Knowing of these difficulties and imports.
Well, apart from the fact that we say he wasn't appointed, but be that as it may, that I've addressed already on the question of rationality, and that it doesn't apply. So, but one can't put the cart before the horse, because you can't say the findings are there and therefore they must be accepted. I simply am puzzled by the suggestion that the chairman must somehow have regard to the findings, but he needn't attach any weight to them. I just don't know how that works.
It'll be for the chairperson in due course. But by the way, have the parties had any further discussions about the possibility that they might agree on a chairperson and initiator, either the principle of doing that or, even better, the identity?
I have no instructions on that, but I should seek instructions. Thank you.
Thank you. Mr. Katz, are you finally ready? And Mr. Labuschagne, I think you may be excused then.
Thank you, my lords. In reply, I'd like to deal with a major point that has arisen in the two-day hearing, and that was a point that I described as the only interesting point in the case at the end of my reply. And that was this question of Mr. Motsoeneng's labour rights and whether or not Prayer 1 is available to the DA. I'd like to deal with that at the end. Before that, I'd like to deal with some 4 introductory points, then turn to this debate that has now happened, then the Minister's argument, and then the other 2 respondents' arguments, and the pieces of it swiftly. The first point, just as a matter of housekeeping, the document that was handed in this morning, I've numbered that from Mr. du Toit, 1098 through to 1108. Just for
1098 to 1?
1098 to 110. The second point is that to the extent that it may be thought that I impugned either of the 4, Mr. Macquarie, Messrs. Macquarie, Edeling, July and Polani, I didn't. To the extent that it may be suggested I did, I apologize. The point, when I made the point that the person went rogue, it wasn't that necessary that Mr. Macquarie was pliable at the outset, but that he went rogue in the perception of those appointing him. I just want to get that out of the way. The third point that I'd like to make as far as this introductory portion is concerned is that when this court considers this matter, we ask that the court, as the dominant feature of the consideration, employ the words that His Lordship presiding put to the Minister this morning. How do we find ourselves in this position? So it's not just a question of whether there's a bit of a mistake here or a bit of a mistake there. The big picture as to how it's happened that since 2007, today, we haven't had a permanent, properly appointed COO, etc., and how we sit in 2016 with 1 non-executive member of the board. How we come to that position should dominate this court's thinking in every aspect of how the court should deal with the case. Just on this last point, which was the point about the public protectors and SABC's understanding of the nature of the, let's call it disciplinary inquiry, merit sanction debate, we want to make 2 submissions. One is it's not necessary for the court to get into it. That's for the Gauteng court or for the disciplinary inquiry if it ever happens to consider. But when your lordship looks at that issue, perhaps it's worth looking at what the words used by the public protector were in her remedial action, which is on page 99. And it's interesting, and it's not a point that's arisen before, and obviously any other party could have an opportunity, if they wish, to comment on it. In paragraph B, this is on page 99, she says to the Minister to institute, and she uses the following words, disciplinary proceedings, and I emphasize proceedings. And she says that in B1 and 4. That doesn't relate to Mr. Motsoeneng at all. So when the public protector says to the Minister, institute disciplinary proceedings, that's one thing. But on the other hand, this is on page 99, perhaps it's an unimportant distinction. On the other hand, as far as the board is concerned, she says something different. She says, vis-a-vis Mr. Motsoeneng, the board must do what? Take appropriate disciplinary action. Now, we're not entirely sure if there's a difference between proceedings and action. But to the extent that the court has this dilemma before it as to what is the status of her findings vis-a-vis Mr. Motsoeneng, for the purposes of the chairperson's inquiry, perhaps the court will be guided by having a look at the difference in wording used vis-à-vis the minister compared to the words used vis-à-vis the board. Now,
can we really leave this question over to the Gauteng case? Because as matters stand, it appears that there's nobody in the Gauteng case that's going to be arguing that it's a sanctions-only.
my instructions have been over the lunch period that my client will intervene in those proceedings. But it's not it's not clear to us what the public protector indeed says about that sanctions merits debate. And I've heard Mr. Labuschagne, I've read the papers, but it seems to us that having regard to that distinction in wording, that issue is open to the Gauteng court, and depending on how that case goes, perhaps to the chairperson.
Well, one of the reasons why the public protector may take the view she does of the report, and I'm not suggesting it wasn't always her view, is that it might make her report vulnerable to review if it isn't a merits hearing.
I can't speak for the public protector, yes, but that could be a reason.
Well, you
but
may also, the DA may also wish to consider that.
But the one question that Mr. Du Toit poses, which I think it would be difficult to suggest that it's not a valid question, is were to be suggested that, for example, a finding made by the public protector stands until set aside by a court, doesn't, let's open quote, bind the chairperson. It leads to all kinds of perhaps difficulties and strangeness, as he's just pointed out. And we agree with him. And that's a reason for our principal stance is which it's sanctions only. And that makes sense when one has a, I mean, how does it work? So the public protector does an investigation and she finds, A, the moon is blue. It's a finding. How could it be that a chairperson can be faced with that finding of a particular fact, but say, well, I come to a different conclusion, and the moon is not blue, it's white?
Well, what if a witness who the public protector interviewed is not available at the disciplinary hearing, can't be found? There may be questions as to, hearsay, and to what extent one can have regard to what that person might have told the public protector, but there may be different evidence.
Those are difficulties. Can't pretend that those are not difficulties.
Can I then ask, you say we don't need to get into whether it's sanction only or not, but you're wanting us to direct a fresh inquiry, and it doesn't seem right that we should be doing that if it's entirely uncertain as to what the scope of that inquiry is. So a possibility would be to say, well, if that issue should be left over for the Gauteng proceedings, then we should make no order at all on a fresh disciplinary inquiry.
The 6 to 9 of our review proceedings, paragraph 6 to 9 of our review, as it pleases the court.
But, the question is, what do you submit? Do you submit that question should be debated in the Gauteng proceedings? Of course, we have to then be confident that it's going to be decided there.
Well, if it's not decided there, then and there are further disciplinary proceedings, that chairperson will be guided by what the parties before him or her suggests, make a ruling, and that would be subject to a review, as this court is faced with a review of Mr. Edeling's disciplinary proceedings.
So are you content that we should make no order as to fresh proceedings?
No, what we suggested is in paragraphs 6 to 9 of the disciplinary hearings case, that's the first case, we suggest that prayers 6 to 9, the directive that there should be fresh disciplinary proceedings, be suspended pending the finalisation of the Gauteng review. Those prayers we sought before the Gauteng review was instituted, the court will recall. And that was also at a time, as prayer 10 reflects, that Mr. Motsoeneng was not acting, but he was the COO at that time because of the suspension of Davis J's order. So 6 to 9, we would suggest, to the extent that the court is with us and is inclined to grant it, have a suspension order which they kick in once the Gauteng proceedings.
And if, for example, the Gauteng court dismisses the review because they say it's late and they don't entertain it and they don't make findings about what the public protector's report means, is the initiator and chairperson going to be in the dark as to what they may legitimately do?
as Mr. Labuschagne put it a few minutes ago, that's a bridge that those persons will get to when they get to it.
Well, one rather doesn't.
It's not desirable. It's not a desirable outcome. We appreciate that. But perhaps
But why should we not look at it? Why can't we not look at it?
Well, what we say is we've made our submissions in respect of the sanctions debate, and we stand by them. But to the extent that the court is concerned that it finds itself in this unusual situation of being faced with competing difficulties, if I may put it that way, competing concerns which run into difficulties, the court may well take the view we don't need to get to that bridge. I understand.
It does seem to me that the question properly arises in this case, and we shouldn't be overly deferential to say, well, it may or will also arise in the Gauteng case.
Well, then we'll stand by our submissions on that one. The court knows our submissions. We've made them. We've made them on more than one occasion for Samela Day, before this court. Let me just turn to the Minister. The Minister's argument concerning the open quote, unlawful, close quote, appointment of Mr. Gwana, we submit her submissions, her initial submissions and her affidavit, which accept that there was an unlawfulness, should be accepted by this court. To the extent that the court has, as Justice Rogers put it, a perhaps different view because of the idea that the shareholder can step into the shoes of the important board by virtue of the Companies Act, as a fact, the Minister didn't do that. And she doesn't say she did it. And she didn't exercise any power that she may have had to do that because she didn't say she did. And for that proposition, we rely on a Constitutional Court judgment of Harris versus Minister of Education. It's 2001, Volume 4, Essay 1297, where Sachs J suggested strongly that under the constitutional dispensation, those old cases where an administrator acts in a way that they had the power to do so, but misconstrues the section or the particular power that they were entitled to act on, is no longer good law. Latif, Avenue Delicatessen, those series of cases.
What must we make with the submission that if one have regard to page 1083, where the Minister, when she signed it in the capacity as the shareholder representative of the SABC. That was, I think, the appointment of
That is Mr. Gwana.
Mr. Gwana appointment.
Yes, that's the request, yes.
No, you say the fact that she doesn't say it, we must not take that into account.
We're not aware of the section of the Companies Act which allows for the shareholder to act qua board when the board is not in a position to act. And it's to the extent that we read the papers, neither was the Minister. The Minister didn't say, well, Section X of Y Act gives me the power as the shareholder to step into the shoes of the board, and I do that. If that's what she was purporting to do. She doesn't say that she did it, and the argument, until Justice Rogers raised it today, hasn't been advanced, and we would suggest that the Harris case is authority for the proposition that even were she be entitled to do so, it doesn't happen. For purposes of the lawfulness debate as to Mr. Gwana's. We have nothing to say on suspension other than that we said in chief yesterday.
What was the reference to the Harris case?
2001, Volume 4, Essay 1297, CC case. There is also the Howick Ratepayers Association case of the SCA, where Cameron J.A. deals with it in a slightly more nuanced fashion. It's 2007, Volume 1, Essay 206, SCA.
Just repeat that, Joe.
It's 2007, Volume 1, SA 206. That's SCA, Howick District Landowners Association. As far as the suspension argument is concerned, we have nothing to add. And to the extent that the court comes to the conclusion in exercise of its discretion that it would be just and equitable to suspend the declaration of invalidity, we ask that the court have regard to the arguments that have been presented. Costs in the main case, as far as the Minister is concerned, We ask for 2 issues to be considered in the exercise of this court's discretion. The one is the rhetorical, how do we find ourselves in this position? Why are we here? And it's easy to point fingers at the DA and say that the DA come smugly to this court on various issues, but we would think that's unfair. If the DA didn't initiate this litigation way back in July 2014, we would have had the difficulty that the Constitution and the Public Protector's powers would have been trampled upon by the SABC board and minister in a manner that is, we would call it extreme. So we ask that the court has regard to that when it comes to costs in general. I turn now to some of the smaller points. Yes. In the replying affidavit in the main case, we don't ask for personal costs against the minister because for the first time the DA has seen that she relied on advice which has turned out to be wrong. That's just neither here nor there. So we're not asking for personal costs in the main case against the minister. That was the point that Mr. Manetchi did indicate during his address. May I turn to some of what I would call the smaller points before getting to the big point? The first small point that we wish to address is that Mr. Motsoeneng's opposition to the disciplinary review case. I just want to make 3 points. He repeatedly contended, and your lordships will go through the papers, 1, that the disciplinary inquiry was in accordance with the remedial action of the Public Protector. He says that over and over and over. 2, he was cleared of all the charges against him. And 3, the inquiry was in accordance with the SABC's Code of Conduct. And for that, we ask that the court have regard to 5 paragraphs, 4.1, 5, 9, 13, and 15, for those 3 propositions. The next proposition that we wish to address is from an extract from a constitutional court case. I've given to your registrar 3 pieces of paper for each of your lordships. May I ask that she hand it to your lordship? The first piece of paper is an extract from a constitutional court case called Eki v. Parsons. And your lordship will see, perhaps I should read it quickly, that what the court does is explains in paragraph 39 the role of the rules of court. And I make this point with specific reference to the service argument that was addressed yesterday, together with the other aspects relating to that point, such as the stay, etc. But the point that Madlanga says is on top of page 53 in the middle of paragraph 39, it says, without doubt, rules governing the court process cannot be disregarded. They serve an undeniably important purpose. That, however, does not mean that courts should be detained by the rules to a point where they are hamstrung in the performance of the core function of dispensing justice. Put differently, rules should not be observed for their own sake. Where the interests of justice so dictate, courts may depart from a strict observance of the rules. That even when one of the litigants is insistent that be adherence to the rules. Not surprisingly, courts have often said it is right that the rules exist for the courts and not the courts for the rules. So we would say, bearing in mind the idea that there hadn't been proper service in accordance with the rules, and the fact that Mr. Motsoeneng is in court, an answering affidavit has been filed, heads of argument, etc., we would suggest, as I said yesterday, that this court should not be tolerant of those types of arguments.
Why wasn't the application properly served, and why is there no explanation for that?
Let me answer it like this. In 3 places on the record, the court will see that the service that took place in this case was not dissimilar to 3 previous cases. And one will see in the record on page 285, 309, and 377, whereas in all of these cases, that's how service took place in respect of Motsoeneng at Sea Point by Ms. Jonker. And in none of those cases was the point ever taken.
Sorry, will you say which cases?
Well, in the cases involving the DA and the SABC vis-a-vis Mr. Motsoeneng,
yes,
on at least 3 occasions, service was affected in those cases in the same way it was affected in this case. I know that Ms. Jonker doesn't say that in an affidavit, but on 285, 309 and 377, when you see the notices of motion.
Sorry, 285, 309.
285, 309 and 377. And in none of those cases was the point ever taken. And one could then suggest, why is it suddenly being taken now? What's the difference between in the very first case, and Ms. Jonker will hear me, in the very first case in July 2014, that's how it was served on Mr. Motsoeneng at the SABC offices in Sea Point. The case ran to Skippers, it went to the full bench in the implementation order, it went to the SCA, not a peep about a problem of service. All of these cases have been dealt with, served in the same way without any problem.
What was the 309 case?
Yes, that's Mr. Bishop says 49, the Section 18 of the Superior Courts Act case to implement.
Execute. And 377?
That's what I call the disciplinary proceeding in this case. Point was never taken.
Yes, for what it's worth, I see that in the affidavit we were given this morning by Mr. Du Toit about the resolution, that the email address of Mr. Motsoeneng is the one that Ms. Jonker said she sent her.
Well, I'm going to come to this document in
the application act.
I will come to this document. I'll come to this document when it comes to my big point. Just on this issue, on record 1137.
Are we on service still?
Still on service. 1137. To the extent that there's a timing issue, one sees. Well, that we would submit that, bearing in mind this history, 26th of October at worst for the DA, the application came to the attention of Mr. Motsoeneng. Then I do want to move on to another point, and that is, and I do want to emphasize this point, although I understand that the court has not seen it quite as attractive as I have, and that is the round-robin resolution, where yesterday I made the point that Mr. Motsoeneng was part of the round-robin resolution, and Your Lordship, Mr. Justice Rogers, said that that was a typo as the papers dictate, and then Mr. Du Toit in the morning pointed out to where on the record it was suggested to be an error. Your Lordship will recall that. And what he did was he referred to record 1066. And now I'll ask the court to go to that page.
1066.
1066. I've taken the page out. Yes, I have it. It's on 1117, paragraph 1117, it is suggested on 19 September 2016, the board decided to recommend that in the interest of continuity, Mr. Motsoeneng should be appointed as acting COO for a short period while the appointment of a new COO was underway. Your Lordship sees that. Now this is 2016, September 2016. This is what Mr. Du Toit referred to. And I suspect this is what Your Lordship, Mr. Justice Rogers, was referring to yesterday in the debate with me. And in the next paragraph, 11.18, it suggests that Mr. Motsoeneng was included on the round-robin resolution. That's 17. But this obviously was an error, and it should not have been included. He did not participate in the decision. That's the decision to recommend that he be appointed as acting COO. But nowhere on the record have we found a similar suggestion in respect of the round-robin resolution, which supposedly approved Mr. Macquarie and Mr. July as the chairperson and initiator. So for purposes of the facts, this court can
was the point in the disciplinary case, was the point highlighted that Mr. Motsoeneng had purported to participate in the decision?
I know this, I know
there was a debate about...
I know the Swiss Bureau problems, I understand those problems, I do understand them. I can't say that it was raised as squarely as it could have been. But what I can say is it was attached to the founding papers, the resolution, the resolution giving rise to the difficulty. And as it was presented to the court in the context of a complaint that the minister had improperly intervened in that process. And that, your lordship will see from paragraph 3 of that notice of motion, where there's that declarator. It's something I have left off in dealing with the minister. There's a suggestion that the minister may properly have done what she did, and therefore prayer 3 shouldn't be granted and we should be dismissed with costs. We would suggest that the memorandum of incorporation doesn't suggest that which our learned friend suggests it includes, which is this implied understanding that the minister can initiate proceedings but go further and appoint the chairperson and the disciplinary initiator. And our submission is fortified by the minister not being part of Skipper's J or the SEA's order as far as that disciplinary proceeding is concerned. So we would suggest that our argument on prayer 3.
Well, welcome to the special broadcast here of the Reserve Bank's Monetary Policy Committee meeting. Reserve Bank Governor Lesetja Kganyago announces the bank's decision on interest rates shortly. The repo rate currently sitting at 7%.
That there's an amendment to the relief sought because we now say 6 to 9 of the disciplinary proceedings may be suspended and we don't need 10. And the amendment of 1 in the main case. Well, let's leave aside that for a second. But the principle is this. When it comes to constitutional matters of this kind, the Constitutional Court has approved the SCA's suggestion that where, and I'll read the words, where constitutional breach is established, this court, and this is the SCA, is mandated to grant appropriate relief. A claimant in such circumstances should not necessarily be bound to the formulation of the relief originally sought or the manner in which it was presented or argued, and that's 2004. I have the SAFI reference is 2004, ZA SCA 47, or the all South African references, square bracket 2004, 3, all SA 169, and particularly at paragraph 18. And that paragraph 18 of Haram's DP's judgment was approved by the Constitutional Court in the appeal against that case. That's called Modder East Squatters versus Modder Club. Well, I wish to come to the last point that I'm going to address the court on, and that's what I would call the interesting point or the big point, the main point. Now, in doing so, we need to understand, we would submit a number of aspects. The first aspect is the suggestion by the SABC that and I'm going to emphasize, the appointment of Mr. Motsoeneng to a particular position within the SABC, short of a board of director, is not subject to review. We submit there can be no traction to such an argument generally, and in particular in this case. Generally, we say, because obviously that type of argument leads to the kind of suggestion, well, I want to work for the SABC, I have a lot of money, so I take R1 million and I go and bribe somebody to get a job, and I get my job, whatever the job might be. And the suggestion from the SABC is, that's okay, courts can't intervene. We would suggest, that type of statement that needs to be suggested to be rejected. More important in this case, the difficulties arise as follows. If one turns to 1098, the document that was handed up by Mr. Toy earlier, perhaps we should just go through it, and I'll turn to some of the other pleading points and then the legislative points, and then try to develop an argument as to why the argument has no traction. And in doing so, my lords...
Sorry, just a moment. What's that 109?
This 109 is...
Did I get a copy of that?
Yeah,
Only you got it.
No, I think it was dealing with...
No, I think I...
The hand goes back to me, that's one.
Oh, it is the same. Yeah, it's the same.
I've got it.
Well, look, in introduction to this big point, we want to affirm the point that I made earlier, that the court will have to ask, why are we here? But you'd also ask another question in deciding this big point, the main point. and that is, what is the SABC's attitude? What are their arguments in general in this case? Leave aside Mr. Motsoeneng for a moment. What is the SABC's suggestions generally? And this will all come to why we're entitled to prayer 1 in the main case as prayed. This is an affidavit by Lindiwe Bayi, dated I think it's the 22nd of November. And perhaps I should just go through the affidavit and take the court through the annexes, because it was handed up this morning and it's a replacement of a page that was attached to the SABC's answering affidavit, wrongly, she says. She says that she's the company secretary of the SABC. She says, on 11 November, I prepared a draft resolution for consideration and approval by whom? By the SAP Executive Committee, EXCO. That EXCO resolution was to authorize Mr. Aguma to sign all legal documents and do all things necessary to oppose this application by the DA. That's on 11 November. On 11 November, I submitted this resolution to EXCO by email, round robin. The resolution was duly approved. I annexed copies of the signed return sheets of the EXCO members and copies of emails from 2 persons. Let me stop there, my lord. It says the resolution was duly approved. Now we know statutorily that EXCO consists of 3 board members plus 11 other members. It's 14. Nowhere in the Broadcasting Act is provision made for what a quorum should be for those 14 members, number 1. And number 2, when one has regard to the chart or the memorandum of incorporation, one doesn't see any provision for quorum. Then she says it was a replacement document, and she turned to the page, and here on page 1103 LB1, one finds the round robin resolution of 11 November 2016. And she sends it to the group EXCO. One sees a number of persons that it's sent to, the first person being Anant Mudlia, and there's a number of persons that it's CC to, Chantal Bremner and others. But the important point for our purposes, and for Mr. Du Toit's argument, is that the 4th person identified as one of the people it's sent to is Mr. Motsoeneng. So as of the 11th of November, Mr. Motsoeneng, as an employee, who's not a board member, Mr. Du Toit says, well, it's fine, because he's not a board member, therefore this court can't intervene in his employment, but he has the power with others to deal with this case. And he says, I hereby, well, I presume, because it's duly authorized, we don't know what the quorum is, and we don't know whether he's round robin or not, whether he signed it as part of his round robining. Mr. Motsoeneng himself was a party to the round robin resolution which authorized Mr. Aguma to depose to the affidavit.
Sorry, where do we find out what the composition of the executive committee is?
No idea. It's not on the papers.
Sorry, you said you identified the people who are party to it.
No, what I say is this. The Broadcasting Act, in section 14, provides that the corporation, the affairs of the corporation are administered by an executive committee. This is EXCO. And they consist of the CEO, the COO, the CFO, and no more than 11 other members. The EXCO is accountable to the board. And an executive committee must perform such functions as may be determined by the board. The point here is that we know as a fact that in September of this year, Mr. Motsoeneng was appointed to a position as one of those EXCO. He was appointed to a position of employment which made him statutorily one of these 14 persons, or one of the 11, 3 plus 11. The point that I'm driving at is this. To the extent that there can be any traction at all in a suggestion that when the Department of Home Affairs or the Department of Sea Fisheries appoints a sea fisheries officer, the DA has no role to play in that appointment. That's given a lie to the role and the place of Mr. Motsoeneng subsequent to his appointment in September 2016, bearing in mind this difficulty.
You don't come to court to say that the reason why his appointment is bad is that he belongs to the executive committee.
No, I don't say that, but what I do say is, to the extent that there can be any suggestion that courts should be slow, if they can at all, intervene in employment contracts by state institutions. We submit that they can in all circumstances. But to the extent that it could be suggested that there may be this area, this grey area, where the Department of Home Affairs appoints a particular immigration officer for a particular port of entry, and the DA come along and we say we don't like that appointment, they come to this court and say that appointment was illegal. That's the suggestion. The suggestion is, well, in those circumstances, the court has no role to play. To the extent that there can be any traction in such an argument, it falls at the first hurdle when one has regard to the particular position. Leave aside the Public Protector's report et al. That Mr. Motsoeneng was appointed to. He was appointed to a position that Section 14 has as an effect. He's part of the Executive Committee.
Well, we don't know that. The identity of the other 11 people isn't determined by statute.
No. I want to turn...
But there was... are you continuing with this point? Because Mr. Du Toit cited some authority, which I haven't yet read, suggesting that this is not administrative action.
Yes.
Are you still coming to that? Because otherwise a fairly important issue is being dealt with in rather broad brush.
Yes, let me I have two submissions. It's called Gajima. Let me caution against the court relying on what Kachalia J.A. suggested in this court, and it's a caution, no more than that. 2 weeks ago, I was arguing in a case called Oricon in the Constitutional Court, A-U-R-E-C-O-N. It was an appeal from, an application for leave to appeal from the Supreme Court of Appeal, which in turn was an appeal from a decision of this court by Yukisa J. And it seemed from the debate that the Jagima Russia on certain aspects may be up for some debate.
So in which court is that?
That's the Constitutional Court. Oricon, A-U-R-E-C-O-N. So I'm very alive to the case. And the case, in that case, the City of Cape Town, and I don't want to lose my train of thought, but the City of Cape Town brought an application in this court for setting aside its own tender decision, relying only on the principle of legality, no pudger. Or is it the other way? Maybe it doesn't really, the principle doesn't really matter. The principle didn't. And what Yukisa did was he upheld the review and set aside the tender. It went to the SCA, and what the SCA said that Yukisa was wrong to do so because of a time problem. There was an unreasonable delay, and it overturned Yukisa J and set aside the setting, or reviewed and the setting aside of the original tender decision. But the issue arose as follows. When it came to this unreasonable delay issue, did an organ of state enjoy the rights set out in Section 33 of the Constitution to administrative action? That's how the debate rose in the Constitutional Court. And the relevance of that debate came out of the Gajima decision, which was this, that in that case, in the SCA decision, Kachalia J.A., because of the words of Paja inter alia, found that Paja did apply to an administrative review by an organ of state of its own decision, effectively. It doesn't really matter. The only word of caution that I have is that this court should be slow to rely on the SCA decision, and I say this from the bar, because of the debate that happened at the Constitution. But in any event,
there's no. What was
you are bound by it. We had this debate a year. I had this debate a year ago in October in this court, before Davis, before then. But more important than all of that.
Well, if Kajima is relevant to something we have to decide, then we are bound by it until it's overruled.
But it's not. But correct. But that was the submission that I made a year ago. The problem is that the Kajima decision, Russia, is not at all relevant for today's purposes because of its internally, because of what it was faced to decide, which was this issue of unreasonable delay, either under the principle of legality or under the principle of Paja. That was what the case was grappling with. But in any event, if I may just read you from... Yes. May I just read from Gajima in any event? It makes it even worse, because firstly, it's not relevant, but in any event, in paragraph 38, what Kachalia J.A. says, in my view, the proper place for the principle of legality in our law is to act as a safety net or measure of last resort when the law allows no other avenue to challenge the unlawful exercise of public power. It cannot be the first port of call or alternative path to review when Pudge applies. That's what Mr. Declaratory relied upon. But then the difficulty for the SABC's argument is the next sentence. As this court, SCA, has said in NDPP and others versus freedom under law, there's a reference, the legality principle has now become well established in our law as an alternative pathway to judicial review where Pudge finds no application. So the question arises, does Pudge find application here when it is the question of, in September 2016, there is the so-called fresh appointment? Well, if it does, the suggestion, well, the DA hasn't hitched its wagon to the Pudge review, therefore we're out of court. We would submit that on a case such as this, there can't be any suggestion that if the appointment was illegal, for whatever reasons, we are knocked out because we didn't use Pudge. May I just turn to this question of the illegality of the position of the appointment? Because to my mind, that's what this case is really about. This case, you can take all the bells and whistles from service to minister to everything. What is this case about? This case is ultimately about two things. What happened in September 2016 after the 14th when the SCA upheld Davis J's order? That's what the case is really about. What happened? What are the legal consequences, labour and otherwise? And what is the appropriate remedy, bearing in mind whatever the court finds about it? That's what the case is about. Now, to answer that question, Your Lordship will recall that yesterday I made the submission, which we stand by, that when in June or July 2014, Mr. Motsoeneng was appointed statutorily as the COO, what his 5-year April 2011 to 2016 contract fell away. Perhaps I've got two documents which I've handed up together with. The first is an extract from the Public Protector's report. I think it's page 47, where the explanation, and Your Lordship knows this, at 6.1.2.2, the Public Protector says, this fixed-term contract was for a 5-year period, 1 April 2011, signed by Nicholson and Motsoeneng on 1 April 2011, etc. Mr. Nicholson again inexplicably omitted to insert the year on the date, etc. Leave aside those issues. But so one has a time period, April 2011 to April 2016. That's the contract. In 2014, in the middle of the year, that contract was terminated, dissolved, disappeared, whatever words you want to use, when Mr. Motsoeneng accepted his statutory appointment as the COO. It came to an end. It evaporated. So when the statutory appointment was invalidated, finally, in September 2016, what had disappeared, evaporated, didn't revive. That's the first argument. That's the argument that I made yesterday. We stand by that argument.
Sorry, let me just, before you move on, make a note.
Sorry, my Lord?
Can you just hold on for a minute?
Yeah.
This question can't have not arisen before as to the extent to which a pre-existing state of affairs is reinstated when a subsequent decision which would have brought it to an end is set aside.
Well,
we haven't really been given authority by anyone, but it can't be an entirely novel point.
Well, I want to answer it in two ways. The first way is you don't have to go there for what I'm now going to say, but in a previous life of yours, Your Lordship did debate this with me in a different capacity.
Let's confine it to your submissions.
But it hasn't arisen that I know of in a particular context. Even because you remember what happened in Similani was, it doesn't matter. I'll come to why it doesn't matter. And it's important that Your Lordship knows my argument about why it doesn't matter. Because the only argument that our learned friends had against my proposition is wholly destructive of their own case on this point, and that's what I want to come to. And therefore, Your Lordship doesn't have to decide this as a general proposition for the following reason.
But there is a certain attraction to the proposition that although, despite recent rumblings in the Constitutional Court, administrative action stands until set aside, at least once it is set aside, is it not as if it never happened?
I'm going to come to that. I'm going to come to that.
Also, but that was the first point. You said we don't need to go there.
For the second reason.
For a second reason, but I wouldn't mind knowing, following the first reason to its conclusion before telling me why we don't need to go there.
We say it as a matter of logic, as a matter of common sense, and I know of no authority that suggests the opposite.
But why is it a matter of logic?
The Telkom example that I gave yesterday. The man works for Telkom as an EXO member. He then accepts this new statutory appointment of the COO at the SABC, which turns out to be invalid. You can't just jump back into the position he was at Telkom. Yes, it's the same company in our particular case, but it's not a promotion. If it, under Labour law, if it was a promotion, he would go back into the position that he was. But this is different because of the statutory nature of the jump. His 5-year fixed-term contract came to an end in July 2014. How does it revive? What mechanism is there to revive it other than under the Curlin?
So is your proposition underpinned by the fact that it's a statutory appointment?
In this particular case, it was a statutory appointment, and that statutory appointment had a whole range of other, let's call it terms and conditions, different in kind to the one that we see in 6.1.2.2, reflected of page 47 of the Public Protector's report. It's the end of that contract.
But the only event which you can identify as bringing to an end the previous 5-year contract is the new appointment.
Correct.
It is not as if there's a consensual resignation from one company in order to take up what is believed to be a valid position in another company.
But we would submit.
So why is the post-terminating position, or the contract terminating act, why doesn't that fall if it only has its existence in the fact that he's been appointed to a new post?
Well, those are submissions in that respect, but I do want to turn to the alternative argument, which I think puts pay to Your Lordship even having to consider that main argument, and that is this. The only argument against us, and it's important, my Lord, because this is how the SABC see it, and this is how Mr. Motsoeneng has argued it, is this, that he, as it were, would be regarded as dismissed if we were to come home under prayer 1 in the way that we suggest should happen. The dismissal argument. Your Lordship heard that this morning and yesterday afternoon. I've handed up section 186 of the Labour Relations Act, and I asked that the court go through it because as the alternative to my disappearing argument, we would submit this is a complete answer to the problem. And when Your Lordship has regard to the argument, Your Lordship will have regard to why are we in this position, what is going on here, and what are the SABC argument? Because here's the nut. Section 186.1 defines dismissal. And we are in B because this was a 5-year fixed-term contract, 2011 to 2016. An employee employed in terms of a fixed-term contract of employment.
Yes, this is the part I didn't quite hear when it was being read out, because it's a precondition is that the employee should have reasonably explained.
That's it, my Lord.
Yeah.
Now, how in April 26, assume our main argument is wrong, this is a pairing argument. Let's assume it's wrong, that the contract continued to April 2016 on the basis that the jump to COO didn't cause a disappearance. Then there was a dismissal argument made by learned friends that in April 2016 it should have been renewed, and if it wasn't renewed, then that was a dismissal, and his labour rights are compromised. Now,
Mr. Katz, our difficulty is that this isn't the basis on which the case was put. So, although the nature of these 5-year contracts was stated by Mr. Aguma himself more recently, we don't actually have the April 2011 contract, and it wasn't said, but once the COO appointment was set aside, there was no difficulty because Mr. Motsoeneng was no longer with you anymore.
Well, 1067. They deal with it on 1067. That's the best place that you'll find an answer to what you're asking. On 1067, 11.21,
referring to paragraph 11.22.
11.20 and 11.21, and then 11.22 is the consequences of their understanding of the law, which, as we now see, because of what Section 186 of the Labour Relations Act, is wrong. So what the SABC tell the court, measured against the statute, is plainly wrong, and your Lordship will have to consider that. What he says in 11.20 is the judgment of Davis J did not, however, have the effect that Mr. Motsoeneng was no longer an employee of the SABC. Now, we submit that that's wrong for the reasons that I've articulated, but even if we are wrong, that when Davis J gave his judgment a year ago, Mr. Motsoeneng may, on this argument, have continued in his five-year fixed-term employment contract until April 2016, at best for him.
That's on the assumption that in April 2011, the 5-year contract rule applied and that it was on these terms, which said there was no reasonable expectation of renewal.
Well, even if there was a reasonable expectation of renewal, one has to have regard to the words of 186(1)(b.
Well, if there was a reasonable expectation of renewal, isn't that what makes the non-renewal a dismissal?
Yes. Well, no, I don't say yes. Perhaps. But that's not for this court. And I'll say why. That's an issue between Mr. Motsoeneng and the SABC. And the question goes to whether that dismissal, such as it is, was unfair or not, and what are the consequences of that. But as far as this court is concerned, as of today, what your Lordship has before you is a 5-year fixed contract ending at worst for the DA. Remember, the DA says it ended in July 2014. So at worst for the DA, April 2016, and it would be a dismissal only if the jurisdictional fact of a reasonable expectation that the SABC would renew that contract on the same or similar terms, but the employer offered to renew it on less favourable terms, then it would be, or did not renew it. But the jurisdictional fact has to be there. Now, that jurisdictional fact is an objective fact. Reasonable expectation. It's not what Mr. Motsoeneng expected, it's what a reasonable person in the position of Mr. Motsoeneng would have thought or expected. And one can hardly suggest that an objective, reasonable person in his position in April 2016, this is at worst for the DA, could have expected the SABC to have extended that 5-year 2011 contract, bearing in mind the serious findings which had not, and at that stage the SABC had not chosen to review the Public Protector's report.
If the 2011 contract was, 5-year contract was mutatis mutandis on the same terms as the September 2016 appointment, then the contract itself answers the question, because it expressly says there is no reasonable expectation of renewal. My concern is that the case hasn't really been presented on that basis by your client. It hasn't been presented on the basis that the true situation which arose once the SCA finally determined that Mr. Motsoeneng had not been or refused leave to appeal the Davis judgment. The answer is the DA doesn't say at that point in time, by virtue of the expiry of his pre-existing contract, Mr. Motsoeneng was simply not an employee at all. The point hasn't been canvassed.
Well, we would submit that
it really arises from something Mr. Aguma says, and the fact that he has annexed the latest contract to the papers that,
yes.
that indicates, in tandem with the reversion argument, that the previous position seems itself to have expired.
Indeed.
But
that's the, and my Lord, when your Lordship says, but it has, but whatever, that's our argument. Your Lordship knows the papers, that's our argument. And your Lordship will, and please, and may I come back to Prayer 1. Prayer 1 is a declarator, and there's been much debate about how it fits in, were this court to come to the DA's assistance in respect of Prayer 2. And to the extent that it may be suggested that Prayer 1 is not necessarily the DA's best argument, we would differ. In this sense, if your Lordship grants Prayer, if your Lordships grant Prayer 2, a hypothetical example, and it's not so hypothetical because we know what happens in this case, and I don't want to go back to the nasty words that I used yesterday, but we know, if your Lordships grant Prayer 2, you don't have to have a crystal ball to know that within a few months we will be back here. And it won't be General Executive Corporate Affairs. It'll be General Executive something else. But this time, the remaining board member or the GCO would have considered the Public Protector's report, considered all the facts, and rationally, open quote, made the appointment. That's how it works in this case. You heard the argument this morning. You can't grant prayer 2 because it's not open for debate. So when your Lordship considers this big picture, I'm not going to use those words, that's how it works. It's worked like this from February 2014 and cast a shadow back. How did we get to 2014, February 2014? I repeat the words that Skippers J quoted from the Public Protector. This particular individual has operated above the law in respect of successive boards. And if you don't grant prayer 1, some other judges in this division, some other division, will be confronted with the same, if not a similar case to this case, and they will put to me, why shouldn't we set aside this new appointment and let it go? It's going to happen. So we would ask that when your Lordship, Justice Hlaudi, puts to Mr. True why, or to Mr. Manechi, why are we in this position? That's why. Because the courts have not stood up and said, prayer 1. So when your Lordship puts to me the question, yes, we have the 2016 5-year contract, not the 2011 5-year contract. Your Lordship puts it to me, can't get away from that. We're not party to the 2011 contract. They put up the 2016 contract. And if they were so concerned, as they suggest in paragraph 11.21, the status quo ante regarding these are their words, Mr. Motsoeneng's employment that prevailed at the time was appointed. Why? Is there evidence of that? They should have put up the contract.
Assuming we were to conclude that Mr. Motsoeneng should not hold any senior executive position, unless and until,
yes,
etc. If your client wished to advance the case based on the potential expiry of the April 2011 contract to say that Mr. Motsoeneng is not an employee at all, presumably once that contract has been obtained, I'm not sure where it is, presumably the Public Protector had it and still has it, your client could bring a fresh application to, as it were, go beyond what we granted, where that issue could properly be debated. Is there any...
yes.
If you really want to follow through the notion that... remember, what we've been debating is, first of all, should he carry on as corporate affairs? If not, should there be a wider prohibition against any senior executive position, or should it go further as against any position at all? And the fourth and widest position is, should he be regarded as not an employee at all?
Yes.
Now, paragraph 1 does not actually say he can't be an employee. It just says he may not hold any position. Am I right?
Yes.
So if there's going to be a contention that his employment has in fact terminated once his appointment as COO was finally determined not to be valid, he's no longer an employee at all, because I know you say that...
For the two reasons.
For two reasons, but assuming that the good reason, if it is good, is that his April 2011 contract had run its course and there was nothing valid in its place, then that might be a basis for you to come to court for separate relief to declare that he's not an employee at all. But at the moment what you're seeking is simply that he may not hold a position at all.
No. Assume we get point. You have to. This is always on the basis of that we get point prayer 2. Assume we get prayer 2. Then there's no debate as to whether he can continue in that position. There's no suggestion by any of the parties that declaration should be suspended for any reason. There's no suggestion. So therefore, it's to the extent that your Lordship grants it's common cause he cannot continue as Group Executive Corporate Affairs. Let's accept that. The question then arises: should your Lordships go the step further and grant prayer 1? And we submit for all the reasons, including, let's call it the two labour-related reasons, prayer 1 is appropriate, because if you don't grant it, in the same way that we've heard from all three opposing respondents, the Minister, and your Lordship will see it from the judgment, the Minister, the SABC, and Mr. Motsoeneng, they say the Public Protector didn't issue a suspension order. Therefore, Skippers J, you should not. They made that argument, and your Lordship sees it in Skippers J's judgment. Then they come today, I've heard it yesterday and today, Davis J didn't make the further order that we sought. That's the only reason we're back here in a year's time. Because the type of order that we seek in Prayer 1 was not made. We will be back here. You don't need a crystal ball in a year's time unless you make Prayer 1. And that's the point that we make. And I come back to Justice Hlaudi's question, why are we here? 8 years later or 10 years later with others. And that's the submission. We can't take it further than that, other than the Labour issue, which we suggest that both Labour arguments are good, and we ask that the court to uphold them.
Can you just clarify for me that the factual position is, as I'm now going to put it to you, that once the COO position was finally off the table for Mr. Motsoeneng in
14 September 2016. Yes.
The new position to which he was contracted nevertheless proceeded on the basis that the remuneration package which attached to the acting COO couldn't be reduced.
Well,
sorry, just so that I know, Mr. Motsoeneng, currently, as part of the salary bill, Mr. Motsoeneng is paid the salary of an acting COO.
No. On page 1096, it said when you served as the COO, not acting, COO.
Oh, sorry. Yes.
So is he getting the package of a COO presently?
That's what 1096 says.
And presumably Mr. Guana is also.
I have no idea.
Well, she's an acting. If she's acting COO, she must be getting whatever acting allowances are associated with that job.
Perhaps.
So there are two persons virtually getting the same salary. The one is not doing the job, the other is doing the lesser work.
I didn't say.
Well, it appears on the papers.
Well, it's not just two, because one has the C. The bizarre thing is, it's even worse, because one presumes. Yes, there are two people at the moment, as the papers stand, enjoying the salary of a COO when statutorily there can only be one COO. And your Lordship, in those circumstances, we would submit. And I'm not saying that begging or whatever would be hard pressed not to grant prayer.
I must say I really do battle with that part of it. If the appointment to COO, if he shouldn't have been promoted to that position because he wasn't regarded as a proper person to be appointed to it, it does seem bizarre that his employment should now continue in a lower position. We are told a significantly lower position.
And it's not open. No, it's not. You see, this is the difficulty, my lord. It's not just a lower position with significantly lesser duties, but the same higher salary. And the important thing is the SABC tell you today you can't intervene in that appointment. That's what they tell you.
Well, they say it's rational.
Excuse me?
They say it's rational.
No. They say there's an ouster. They go worse than no. They don't do that.
Yeah,
they say
you're right. They say that doesn't matter. We can't do anything.
They say
about
you can't do it. They say there's an ouster clause in 2016 on these facts, and that's why Prayer 1 is so important, because the SABC will.
Mr. Katz, we are judges. We're here to listen to litigants.
And the argument is Prayer 1 is appropriate because we know what they will do. And the court, not what it's what the court knows. The court should be tired, we would submit, of this dance of prayer, non-prayer 1. And that's the point. Skippers J, SCA, Davis J didn't give a piece of relief that we see, the extra piece of relief. A year later, the same argument is as it pleases the court. And we ask that the court, when it comes to this question of cost, the court knows our submissions. And not just the DA pleading, I say this as an officer of the court, and I've said this for this kind of litigation, which I've been involved in for 20 years, not for the DA, for many poor people, for many NGOs, etc. I think Rogers J put it best in the Oudtshoorn municipality case, that when it comes to this kind of haggling between, in that case, councillors, why should the ratepayers be saddled with that type of cost? And the same thing applies here. We know that there's a judgment in the state capture report where there's that debate going on as to whether it should be the president or Mr. Jacob Zuma himself who should pay the costs of that application. We know that and the debates are raging in this country about these types of issues. But if ever there was a case to set the precedent It's this case. It's been properly pleaded. The individuals who are subject to these types of costa bonis appropriate orders are parties to this case. They've made affidavits. You can assess the affidavits. What your Lordship calls bizarre, Alice in Wonderland, that the kind of language that we have, that's what your Lordships are faced with. And we thank the court for... The one last point that I do want to make, and this applies to Motsoeneng's argument, is this business of service and stays, etc. The blah, blah, blah that I made yesterday. It seems to us, and we make this submission, and the court will decide how to do it, that Section 173 of the Constitution provides this court with the power to regulate its own process. When this court, your two lordships, did that, it would be incumbent upon litigants, and especially organs of state, 165.4 of the Constitution, to respect and uphold the effectiveness of those types of directives, and to come with the kinds of argument that the matter should be struck from the roll, there should be a stay, bearing in mind this court's directives, bearing in mind the history. We would submit is to cut across that duty under 165 of the Constitution. There's no review of your Lordship's directives. Lordships made them in the exercise of a discretion and of power under 173. And we would submit that in all of these circumstances, your Lordship will exercise its discretion, costs prayer one, etc., as it pleases the court.
With regard to your request in terms of names put forward, in terms of the...
At least on the principle, but I suppose we can only take them so far.
Yeah. I was asking whether one further make some decisions. Just in terms of the request that was made by my valid brother with regard to perhaps an appropriate name for the person doing the disciplinary committee and also the person that would be the initiator. I don't know if Mr. Toy, if there any instruction from your side on that one. And
I'm afraid my attorney is still exposed to not being all day. So I haven't gotten instruction on that, but may I suggest, my Lord, that I take an instruction perhaps tomorrow and convey that to your registrar as to what my instruction is.
Can we perhaps suggest that if the parties don't revert to us within 1 week, then there couldn't be an agreement on that issue?
Yes.
I think there'd be two questions. The one is, in principle, are the SABC, Mr. Motsoeneng, and the Public Protector willing to, as it were, vary the Public Protector's recommendation so that the court will nominate or as it were, appoint the prosecutor and chairperson, given that the board itself is incorporate. That's the principle. And the second one, which is can you also, at this stage, tell us who those parties are? Because the alternative, if you agree on the principle but haven't yet had time, or say it's premature to decide who the people should be because it may depend on the Gauteng review and so forth.
May depend on the stay. Or
so it may be that you're satisfied among yourselves that you will be able to agree, but that you don't wish to name the people at this stage. But either way, if you could revert at least within 1 week to say either here it is or we can't agree.
I shall seek that instruction and convey it.
I assume Mr. Maneki will also get involved with that from the minister's side.
This might be proper. We would also take an instruction and confer with our friends.
Mr. Bayes, I see you...
Lords, yes, on this issue, firstly, of the appointment of the chairperson, Mr. Motsoeneng, no objection if the SABC, the Minister and the Public Protector agree to a process. If that process is then to the court to appoint someone, then so be it. But he has difficulty, obviously, with the DA having a say in that process. The Lords, in addition, may I ask for 3 or 4 minutes to briefly deal with 2 or 3 points in brief that came up from the reply. I'll be very brief.
I'll give you a few minutes and about your 3 points.
Thank you.
Don't tell us your first point consists of 3 sub-points.
The relief in prayer 1. We are concerned with the distinction that seemed to have cropped up in the reply, that it deals with Mr. Motsoeneng can't be in a position in the manner that it was seemingly distinguished from he can't be employed. So we certainly do not understand that to mean any particular position, because any employment is a position in that employer. So it pertains to his employment as it reads. So to the extent that there's a distinction to say, well, the DA only asks that it be declared that he can't hold any position, that can mean nothing other than that he can't be employed.
No, it could mean its practical effect is that he's suspended, because he doesn't perform any responsibilities until...
Well, Lord, that is not the case that was presented.
Well, it depends what one understands. He may not occupy any position.
No, with respect, Lord, what we are saying on that point is that's not how it reads, and that's not the case on the papers or in the heads. So it's simply not the case.
That's your first point. Second
Thank
point?
you. The second point simply with the termination of the contract argument. It's not on the papers. It's not the case that they had to be met. If that was the case in the papers, we would have been able to deal with it. For instance, everyone continued with disciplinary, the disciplinary committee issue up to the Supreme Court of Appeal, with a review up to today, and it is only an employee who can have a disciplinary hearing. So with respect, that whole case is outside of the ambit what we had to deal with here.
Well, he was a COO at that stage.
It's a disciplinary hearing, and there was no suggestion that he was not an employee at any stage. The point is, we were not called upon to deal with that case. My lords, with respect, do not know what the case would have been if that issue was on the pleadings. Because Mr. Katz said, you must make these decisions because this is a properly pleaded case. So let us stay then with the properly pleaded issues with respect.
The third point?
The third point. No concession has been made by Mr. Katz on the, as he calls it, the technical issues around the service. The point is simply this. Of course, a court can regulate its process and can condone non-compliance. That was the starting point of our argument. It misses the complaint. The DA still had not, at any stage, sought to explain their difficulty, and trying to now, with reference to notice of motion that happened before, say, well, we were warranted. They're only saying we are in the habit of breaching the rules. That's all it says. We know what Swissburger says. You can't pull out little documents and now build a new case around it. The Lord's one factual correction, to the extent that it may be so. The Lord, Justice Rogers, mentioned that I see that the email on some of those is the same email that as Jonker said the papers were sent to. Just want to point out that we've never said the email was wrong or anything. On the papers, it's clear that it was simply said, well, it was just not received. Just to clarify.
Thank you, Mr.
Thank you, my lords.
I think I'm entitled to the last word.
Just before you do that. Yes, Mr.
Yes, just on this point of the proper pleading and this question of why I'm entitled to argue that on the 14th of September Mr. Motsoeneng's relationship with the with the SABC ended. On page 51, paragraph 139, Mr. Self says the following. He says the DA assumed that Mr. Motsoeneng's involvement with the SABC would end, or at least that Mr. Motsoeneng would no longer occupy any senior position of trust in the SABC. That is not what occurred. And he says that with reference to 138, which is the SCA judgment. To suggest that up to the 14th of September, there was no employment contract that it was never argued by the DA that there was no employment contract is correct, because there was an employment contract until the 14th of September, but on that day it ended, and that's what we've pleaded properly. It's dealt with, just for the record, if your Lordship wants to make a note, on page 826, paragraph 135 of the answering, as it pleases.
Is that all? Thank you. Well, firstly, on behalf of my learned brother and myself, we'd like to thank all counsel and the attorneys for all the paper that's been generated, the submissions that have been made, and the helpful heads in this particular matter. Judgment will be reserved, and we will endeavour to deliver judgment still within December. We will inform the attorneys of the date. Court will adjourn.
I didn't enjoy the part.
Yeah.
Couldn't upgrade, we had to upgrade something special.
You get your name.
Thanks. I'll just focus then. Thanks so much, Anton. And 186 on. Elzan. Victoria. Yeah. Cheers.